Good morning, everyone, and welcome to the second of our HRLaw webinars for 2023. I'm Joanna Chatterton. I head the Employment and Immigration team here at Fox Williams. Before we start, a few admin points, and then I'll introduce our speakers today. The webinar will be recorded and made available to those who have registered but are unable to join us this morning. We're very happy to take questions on the topics under discussion. Could you please put those into the Q&A function rather than the chat box, and we'll aim to cover that at the end of the session once the speakers have finished their pieces. Now, you may have spotted that we have made a change to the content of today's webinar. Unfortunately, my partner Sasha, who heads our immigration team, cannot join us today because of illness. So instead of an immigration checklist about bringing staff to the UK, we're going to update you on recent government proposals to reform employment law. We will be likely dealing with the immigration checklist in a future event. So if I can introduce, please, my colleagues, Kerry, Kirby, who many of you will have seen on these webinars before. Kerry is our professional support lawyer, and she's going to discuss some of the key legal considerations in relation to individual redundancies. We thought this topic might be of interest because in the current rocky economic conditions, we're being asked to advise a lot on redundancies. And the likelihood is that some of you might be looking at that as an option to protect and future-proof your business. Grace Waterhouse is an associate in our team, and she's going to talk through some tricky redundancy scenarios to illustrate some of the practical difficulties that you might come across, and also to provide you with some top tips on how to address them. Kerry is then going to join us again with a roundup discussing the new consultation to change aspects of the working time regulations in TUPE, which you may have read about last week, as well as the proposal to introduce a 3-month cap on non-compete clauses. Look forward to looking at your questions as we go and answering those at the end, but for now I will hand over to Kerry. Thank you.
Good morning, everyone. I'm going to start by providing a brief overview of an individual redundancy process. It's up on the flowchart on the slide. It's no doubt familiar territory to many of you, but there can still be legal pitfalls for the unwary. And one thing to say is that it's different to the collective redundancy consultation process because there are no hard and fast legal rules as to how to inform and consult employees, and no applicable ACAS code of practice as there is for disciplinary and grievance procedures. It's case law guidance that applies, and there are lots of relevant factors to take into account, with the underlying principle being one of fairness to the employee. So first off, employers should ensure that they consider and record the business case for the proposed redundancies. I've highlighted that in green because I'm going to come back to that one shortly. And then depending on how many proposed redundancies there are, the particular roles, and whether others are performing the same or similar roles, you might then need to pool the employees, apply selection criteria, and score them to identify who is provisionally selected as redundant. Next up, you'd be inviting the relevant employees to an at-risk meeting to kick off the process. They're likely going to want to discuss the selection process and how scoring will be applied, so you need to be prepared to explain and justify your approach. They'll also probably want to know the terms of the redundancy package if the worst were to happen. So if you decide to be upfront about the numbers early on, it could even encourage some employees to suggest that they should go early. Or it might prompt an opportunity for a protected conversation if the intention is to boost the redundancy package in exchange for a settlement agreement. But where you follow the process through to its conclusion, you'll be holding consultation meetings with those who are provisionally selected, and throughout the process, you'll need to consider whether there are any suitable alternative roles in the business that could be offered. The remainder is pretty much self-explanatory, so a final meeting to confirm the redundancy, followed by formal written notice of dismissal, confirming notice period and other relevant departure details, such as statutory redundancy pay, outstanding holiday, return of property, those types of things. And then a right of appeal should also be offered, and a meeting held if the right of appeal is taken up by the employees. Next slide, please. So just starting with the redundancy business case and thinking about why it's so important. Well, really the success of the redundancy process, by which I mean not having to defend tribunal claims, can hinge on whether there's a genuine business reason for dismissal on grounds of redundancy in the first place. And the starting point is the statutory definition that's set out in section 139 of the Employment Rights Act. And the wording itself is pretty convoluted, so I've not put it on the slide. But in plain English, the definition applies where the dismissal is wholly or mainly attributable to the closure of a business entirely, the closure of a business site, or a reduced need for employees to carry out a particular kind of work. And in practice, that last category is the one that can be a bit tricky. I think it almost goes without saying that there should be an objective business reason behind the redundancies, but sometimes it can be an area that's overlooked by employers who get caught up in the outcome and what they're trying to achieve, rather than perhaps spending sufficient time at the start to make sure that they're on solid ground when it comes to the eventual dismissals. And it might be that there's been, say, a dip in turnover, or the loss of a key client, or a significant contract, or you just simply no longer need quite so many managers. I think that whatever the underlying reason, communication is key. So employees should have a really clear understanding of the business case. The explanation that you provide should be easy to grasp, and your comms should all be consistent. It can really help the process go more smoothly, limit the pushback from employees and the potential for future dispute if they understand the business rationale. It's also important to back your business case up with a helpful internal paper trail. And I'm thinking here of sort of board or strategy meeting notes, or a written business case, or internal emails that are discussing the proposed redundancies. And I think that the word proposal is key here. The language that you use in relation to redundancies needs to be chosen quite carefully. It's important to remember that it's not a done deal. It's a proposal that's subject to consultation with the at-risk employees. Your internal comms should really support that position, rather than suggesting that dismissals are a foregone conclusion before the process has even started. So in particular, be careful with draft paperwork behind the scenes, things like departure announcements or dismissal letters that have named employees in them before anyone's even been scored or selected for redundancy. Next slide, please. So a genuine redundancy is a fair reason for dismissal under the Employment Rights Act, but it's got to be genuine and not a sham, essentially, to cover up the real reason, which could be performance or conduct or just a clash of personalities, say. And I think in that sense, it's best to avoid the temptation to offer redundancy as a neutral, no-fault dismissal if there is something else going on behind the scenes, like poor performance, but perhaps there's no appetite to follow that particular process. Using redundancy to gloss over that can easily come unstuck. And one thing to bear in mind is that if there's a regulatory relationship to think about with the FCA, for example, then it really is quite important that the dismissal reason is accurate, because it has a knock-on impact on the individual's fitness to perform the particular regulated role, as well as things like regulatory references. And what we've seen from the tribunal is that it can also affect any compensation if the employee were to bring a successful tribunal claim. In the Rent Plus and Coulson case from last year, the EAT upheld the tribunal's decision that the employer should have applied the ACAS code, because redundancy had actually been used to cover up the fact that the decision had really already been taken to dismiss the employee. And that decision was based on the CEO's perception of the claimant's poor performance, and it was linked to discriminatory assumptions. So therefore, a failure to follow the code in that case meant a 25% uplift in unfair dismissal and discrimination compensation. Another point is that you should be prepared to explain to employees the alternative options that the business has considered and why less drastic solutions, perhaps say a recruitment freeze or pay cuts, just won't work. I think proactive is better than reactive with this issue. Although there's no express obligation to consult about ways to avoid the redundancy, as there is if it's a collective redundancy process, you're still probably going to be asked the question in the individual meetings. And really, it's an issue of fairness. If you look at the recent Loving Angels Care and Mindurwa case, That was an unfair dismissal example from the pandemic. The EAT there upheld the tribunal decision that it was unfair for an employer not to at least have considered the possibility of furloughing an employee back in 2020, because that would have been a reasonable alternative to redundancy. So the message is, do think about alternatives, even if you eventually discount them for valid reasons. And keep in mind that there are various ways that employees can access your information and your communication around the redundancies. They might request a written statement of reasons for dismissal, for example, and they're entitled to that if they have 2 years service, or from day one if there's sort of pregnancy or maternity leave in the mix. And really that requires an employer to pin their colours to the mast, so to speak, in terms of the reason that they give for dismissal. Because if you were to change the reason that you gave originally at a later stage, it would certainly undermine any defence that you might run in a tribunal claim. And personal data can also be obtained by employees through the submission of a data subject access request. I'm sure you've all come across that before. It is a common tactical move for employees who are trying to build a case against their employer. And similarly, if things were to progress to a tribunal claim, there would also be a disclosure process, and employers would need to disclose all relevant information in relation to the issues that were in dispute in the claim. Next slide, please. So just moving on from the business case and thinking more about the selection process, and that in itself can be one of the trickiest issues. So a tribunal generally won't submit its own view, but it will consider if the employer's choice of pool was within the range of reasonable responses that was open to it. And that's the test under Section 98(4) of the Employment Rights Act. So you do have considerable leeway, but you have to have given it some genuine thought and be able to justify your approach. Broadly, a pool would normally contain employees who are performing the same or very similar roles. So it might be, say, all line managers within a particular business unit, or it could be, say, all accounts assistants within the finance department. And I think a sensible starting point is just to really drill down into what an employee does on a day-to-day basis and to think about what their contract says about their specific role. The next issue would be whether to include those who have interchangeable skills, who do different kinds of work, or that where their contract allows for that to happen. I think it's more likely to be an issue in sort of low-skilled roles, where an employee might be able to argue that they could do the role of someone else who's been left out of the pool. But it might also apply in other contexts. Sales would be an example where such kind of sales skills might be easily transferred to different areas of the business, different products or different services. But having said that, it can also be perfectly reasonable for employers to keep the pool simply to employees who are doing the same or similar work. And it really all comes down to context and relevant background. Understandably, I think employers are usually keen to keep the pool as narrow as possible, because the less employees in the mix, the less internal disruption and uncertainty. And obviously there's the risk that you might end up with people in the pool that you're really keen to actually retain, but who in themselves might have a bit of a wobble about being included and therefore start looking for roles elsewhere. And in contrast to that, employees might well argue that the pool should be wider because that would reduce their chance of eventually being selected for provisional redundancy. So it's all a bit of a judgment call and a risk management exercise. It is possible to have a pool of one, albeit I think it's sometimes harder to justify that approach. If you've got, say, a standalone role that you just simply no longer need and you can justify that, then fine. But if you have several people who are doing the same role, but what you do is apply a selection criterion that narrows the pool down to one, then things do start to become more tricky. And there has been some recent case law on this. So the Magani and Bradford Teaching Hospitals case from last year is a good example. A nurse was selected because her fixed-term contract was the first one to expire. And the dismissal was eventually unfair because meaningful consultation would have involved giving her the chance to input on the use of the criterion, and perhaps that could have resulted in the employer changing its mind. And similarly, the recent case of Texera, excuse my pronunciation, but that one involved also a pool of one, but it was a chef who was chosen from a group of 10 on the basis that he was the only one who didn't have a specialty. And again, the tribunal held that some warning and consultation might have resulted in a larger selection pool or different criteria. And the EAT went on to hold that the dismissal was not necessarily inevitable at the time it had taken place, and therefore he was entitled to additional compensation for unfair dismissal. Next slide, please. So thinking now about selection criteria and the scoring process. You may well have a standard set of selection criteria that you use each time it's relevant, but just going right back to basics, any criteria should ideally be objective and reasonable. I've put a few common examples on the slides. So disciplinary record, for example, but preferably not expired warnings, measurable performance, for example, where there's been regular appraisals, skill set, experience, they're all common criteria that we might come across. I haven't put length of service on there, but that can still be used in the mix. It's just generally best not to put too much weight on that. And so you might decide it's more helpful in a tie-break scenario. And I think it's important just to bear in mind any discrimination risk. If you take something like flexibility, which I've popped on the side, it's really quite a subjective criterion. And what does it mean in practice? Are only full-time workers flexible? Or is it those who can stay late in the office or who can drop everything and attend client events at short notice? Because the obvious point there is that it could well disadvantage those who have childcare or caring responsibilities outside of work. And the tribunal has generally accepted that that's more likely to mean women. So there is inherently an indirect sex discrimination risk. And just keep in mind that if arbitrary criteria are used without previous discussion with employees and it significantly affects who will be selected, then it's just far more likely to be the subject of challenge. When it comes to scoring, do make sure that line managers understand what's required of them and that they have sufficient experience and knowledge of the employees to take a consistent and measured approach. If you can limit the element of subjectivity, then I think it's harder for an employee to argue, say, that they've been discriminated against or that they've been selected because their manager just hates them. And as ever, make sure you back up the scores, ideally with internal records. So written appraisals, reviews, perhaps remuneration or bonus awards, those types of things. Next slide, please. So I think to conclude this section, there are various reasons why it's important to get redundancy right. And the risk of employment tribunal claims is the first obvious one. It could be basic unfair dismissal if an employee argues that there was no genuine redundancy scenario in the first place, or that the process itself was unfair based on established case law principles. Redundancy could also be automatically unfair, so meaning no need for 2 years service, if it was for a prescribed statutory reason such as whistleblowing, or if it's connected with pregnancy or childcare, or you've not offered an employee on maternity leave a suitable alternative role. You could also face discrimination allegations if the employee believes that they've been selected because of a protected characteristic. And age, sex, disability, those are all generally the most common that would crop up in this scenario. And aside from the risk of tribunal claims, your reputation as an employer can take a bit of a knock. And obviously a badly handled redundancy process can really dent employee morale. But I think if you're strong on your redundancy business case at the outset and your on the record redundancy process ticks the fairness boxes, then you're also in a good position if your intention is actually to negotiate an enhanced package as part of an early exit. So I'm just going to hand over to Grace now to provide some top tips in real life tricky scenarios.
Thanks, Kerry. Yes, as Kerry mentioned, we're just going to walk through now a series of scenarios surrounding one redundancy process. And these are all fairly typical scenarios that you may be familiar with. You would be particularly unlucky to get all of these at once, but it has been known to happen. So let's have a look at the background. You work in the HR team of a large fintech firm. The firm deals directly with individual clients through contact centres. In a bid to save costs, the firm has decided to deal with some of these conversations via automation, so it doesn't need as many contact centre staff. It has decided to remove 10 of its 20 call operator roles and 1 floor manager role. What are the next steps, and how will it decide which call operators to make redundant? Next slide, please, Eva. So as Kerry's already discussed, the first step in any redundancy like this is preparing the business case, which clearly identifies the genuine redundancy reason. Here, there isn't a site or a business closure, but there is a reduced need for people to do the particular role. And that reason is quite clear. The business needs fewer staff to take phone calls because it's automating that process, a scenario that's unfortunately becoming far more common. So let's make sure we're thinking about the detail of that business case. Does it make rational sense? For example, why have we selected 10 staff? Have we done the maths to ensure this can be backed up? Make sure your managers know about your legal obligations from an early stage. We all know the situation where a manager's gone off on a frolic of their own and told a group of employees their role's been made redundant and the decision's been made. As Kerry has forewarned, that jeopardizes your legal position because you need to have consulted with your employees at a meaningful stage, not as a formality when the writing's on the wall. Be upfront in your communications with staff. Explain the business case clearly so they can understand the reason their job's at risk. Now, we might not want to jeopardize the welfare of all of our call operators by informing absolutely everyone in the pool that they're at risk. You might consider it more appropriate to conduct the selection process and then only inform those 10 who've been provisionally selected. That won't always be appropriate, particularly if the pool's extremely small, but commercially is sometimes the best option. And here I don't seem to have any red flags to prevent this. We do need to be managing employee expectations about the process. And one of the biggest factors on people's minds will be the possible outcome. So if you're planning on enhancing redundancy pay, informing the call operators at the start can help smooth that transition process. And even if we're not, making clear what they'll be entitled to if they're made redundant can allay some initial fears about finances and then head off any issues before they start. Thinking about how to choose who'll be provisionally selected, we've got a pool of 20 call operators. So what are the key skills you look for in a call operator? Is it efficiency, perhaps, or complying with scripts and policies? Think about any particular objective criterion that we could score against. That means a criteria that can't really be argued with. For example, how many calls were taken in a set period? How many complaints were resolved? If you have performance targets for these staff, use them as a starting point. Or if there have been appraisals and scores, you can use these. But once you have some proposed criteria, look carefully at them. Are they as objective as possible? Have we weighted them appropriately? Could they be discriminatory in any way? Do we need to make adjustments for any employees who might be on leave or have disabilities? For example, if we've picked the number of calls taken in the last month, have we prorated based on leave or part-time workers? I've noticed it on the slide, but for clarity, we should be including absent employees in this process. But importantly, don't get caught into the trap of scoring somebody down because they've been off on maternity leave or long-term sickness absence. And we'll be thinking about that in more detail as we go on. Next slide, please, Eva. So you make your selection and you inform those call operators and the floor manager who are provisionally at risk and start consultation. You've been consulting with the floor manager, Dave, over the proposed redundancy of his role. He sends you a sick note, which mentions stress and anxiety. It's unclear when he'll be able to return to work. How should you handle this? What would you do differently if Dave had a long-term condition which he managed while also working? Now, this is, I'm sure, for many of you, very familiar ground. And taking away any cynicism, redundancy is undoubtedly an overwhelmingly stressful experience for employees. It often comes out of the blue, it happens quickly, and individuals can feel very out of control. So we need to be cautious. Next slide, please, Eva. That doesn't mean we need to press pause on the whole process and wait in limbo. In the first situation, Dave says he's got stress and anxiety. But that doesn't necessarily prevent him from continuing the consultation if you make some slight changes to the process. So the first step, confirm he's still able to attend the consultation and offer him some flexibility. Would it help to make the consultation meeting remote? Or would he prefer to submit any questions and receive responses in writing? Would he prefer a completely neutral spot or for you to come to his house? These are all things that you can suggest to try and get over the sickness absence issue. Sometimes employees refuse to engage in consultation completely, whether because they're too stressed by it or perhaps angry about their selection. In that case, and if you've already tried to understand why they're taking that approach and you've made suggested changes to the process, you might just decide to proceed in their absence. If you are going to do this, you need to inform the employee of that in advance, and that any decisions made following the meeting will be without their input. In that case, have a consultation meeting in Dave's absence, record what you discuss, and send the minutes to him. For a long-term condition, we have an added complexity, which is the possibility that Dave is disabled for the purposes of the Equality Act. And if this is the case, he does have added protection. Hopefully, we've already gone through our selection criteria to make sure they're not generally discriminatory, but let's take another look to make sure they don't interact with Dave's specific condition in some way. In other words, has Dave been scored poorly because of his disability? And this does require some thought. Has his long-term condition impacted his performance in some way? Does Dave find it harder to complete management forms, for example, because of his condition? A fairly recent case in the tribunal involved an employee who was dyslexic, and when applying the selection criteria to her performance, her employer relied on certain flaws in her work, which were that she was prone to inaccuracies, which related to her dyslexia. And her employer was found to have discriminated against her because it should have discounted the effects of her disability when assessing her. So don't fall into that same trap. Think about this and adjust the criteria accordingly. You as the employer also have a duty to make reasonable adjustments so that Dave isn't disadvantaged in the process as a result of his disability. What might they look like? Well, speak to Dave to understand what he struggles with. Does he need a family member to sit in with him in the meeting rather than a colleague? Does he need longer to prepare for the consultation? Remember that the duty to make reasonable adjustments doesn't just apply to the selection and redundancy process. It will also apply to job vacancies and application processes. So you need to make adjustments to those processes if Dave will be disadvantaged from applying for alternative roles because of his disability. Now, reasonable adjustments doesn't mean agreeing to everything. You don't have to go beyond what is reasonable. And helpfully, case law has confirmed that the duty to make reasonable adjustments doesn't mean an employer has to give a disabled employee a new role as a priority. Next slide, please, Eva. So you've dealt with Dave, but now you have Maria. You also receive a grievance from Maria, one of the at-risk call operators who scored badly. She says that she ought not to be at risk of redundancy in the first place because she's on maternity leave. She's also disputing her score for performance, pointing to the fact that she's been on maternity leave for the last 6 months. Next slide, please. Now, here we have a whole host of issues to deal with that, again, regularly crop up in the redundancy process. We've got a grievance and various complaints around maternity leave. Firstly, thinking about the grievance. Employees will often pop in a grievance during the process, sometimes to try and slow it down or just for nuisance value if they're seeking compensation. Other times because they think the whole process is a sham or they have genuine concerns. The main decision to make when you receive a grievance is whether it can be dealt with as part of the redundancy or whether it needs to be dealt with separately. And to decide, you need to look at it and see what it relates to. So for this one, is it a complaint about Maria's selection for redundancy? Perhaps a concern that she's been selected due to her pregnancy or the selection criteria aren't fair for her? If so, the appropriate forum for this is the redundancy consultation, not a separate grievance process. The consultation should address Maria's concerns with the people who made the decision and help her to understand the business reasons for her selection. If it's a complaint about something entirely separate, which under the circumstances is unlikely, you may wish to run a separate grievance process, but that doesn't necessarily need to slow down the consultation process. A grievance can be run by other people concurrently, or you may wish to deal with part of a grievance separately to the redundancy consultation. Make sure you have a look at your grievance policies to make sure you're complying with those as well. To me, from what we know, this grievance looks as though it specifically relates to the redundancy process. So let's deal with it in consultation. Maria seems to think she shouldn't have even been considered for redundancy because she's on maternity leave. This is not the case, Maria doesn't have the right to be excluded from the redundancy process, and it would be disproportionate to take that kind of action. In fact, if you're specifically selecting Maria as a call operator to retain because she's on maternity leave, you run the risk of discriminating against the male employees in the pool. Maria should have the same consultation process as everyone else, whether or not she's on maternity leave. Next slide, please. Maria's also disputing her score because she's been on maternity leave. Now, we need to be careful here. On the one hand, you can't score Maria down because she's been on maternity leave and therefore hasn't been performing at all. But on the other hand, you can't score Maria up because she's been on maternity leave and you're worried about a discrimination claim. Both approaches will land you in risk of a potential claim from either Maria or her male comparators. You're required to mitigate against the disadvantage Maria faces, but not so as to automatically favour her. Instead, the best approach is probably going to be scoring Maria in the same way as the others, but using the period before she went on maternity leave to assess her performance. This way, her maternity leave is unlikely to be relevant. Next slide, please. So finally, you've addressed Maria's complaints and you're about to hold a final meeting with her to confirm her redundancy. She emails you to point out that a sales role has come up in another company in the same group and claims she should be offered it because she's on maternity leave. The role is in Manchester rather than London. Is she right? Next slide, please. So the law in this area is a little technical. It can result in quite significant liability, and importantly, it's changing. To think about the answer, we have to go to Regulation 10 of the Maternity and Parental Leave Regulations. These say that where an employee is on a period of ordinary or additional maternity leave and subjected to a redundancy process, before their employment ends, they are entitled to be offered any suitable alternative vacancy that's available. And if an employer fails to do this, then the employee will have a claim for automatically unfair dismissal under the law. So the effect of these regulations is that they give Maria a priority over other employees to a vacancy which arises if it's suitable. It's actually one of the only examples we see in the law of positive discrimination in this way. Now, the job Maria has in mind is with another company in the same group. That doesn't matter because the regulation extends to roles in an associated employer, which will include group companies with the same parent. It also is in Manchester, not in London. So the question for us is, does it count as a suitable alternative vacancy? And you'll see on the slide how that is defined. The job needs to be both suitable and appropriate for her to do in the circumstances, and the capacity and place in which she is to be employed and the other T's and C's of her employment must not be substantially less favourable to Maria than if she'd continued to be employed in her old job. Now, if the job isn't a suitable alternative vacancy, we're not obliged to offer it to Maria, so it's important to make that assessment correctly. Interestingly, one of the points we're going to have to consider here is whether the job in Manchester is likely to be less favourable to Maria than a job in London. And this has come up before in case law. There was a case called Simpson in which the tribunal decided that an employer wasn't obliged to offer an employee who had worked in London a vacancy in Cheltenham because its location was substantially less favourable to her. Now, I do not intend to debate the pros and cons of Manchester versus London on this webinar because I have no way of knowing where you're all joining us from. I suspect that the argument might be more difficult in this case than in the case of Cheltenham because Manchester's a big city, but importantly, we don't know about Maria's circumstances. It might be that Manchester suits Maria perfectly. The important thing for you to do is to look at the roles that come up and determine whether you think they're suitable alternative vacancies and offer them to those on maternity leave if so. It might be for the business that it's quite happy to offer her the Manchester role. And if it's not, you might want to spend some time thinking about the downsides of living in Manchester. There's one more point to note about this issue and from me more generally, which is that there's currently a new bill going through Parliament, which those of you who attended our last webinar may remember. This is the Protection from Redundancy, Pregnancy and Family Leave Bill, and it extends the existing redundancy protection beyond the period of maternity leave or adoption leave to cover the period of pregnancy, so from when the employee notifies their employer, and the 6-month period immediately following the return to work after that family leave. So it's effectively extending that protection to before and after maternity leave. We don't know when that change is going to happen. It's likely to be imminent because it's waiting its final stage approval from Parliament. But it's a good idea to update managers now on the enhanced protection that will soon apply. That's everything from me. If you do have any questions, just do put them in the chat and we'll do our best to answer them. In the meantime, I'm going to hand back to Kerry, who's got a short update for us on recent employment law reform announcements.
Thanks, Grace. Yeah, so you might have spotted that there was a flurry of activity a couple of weeks ago from the government. They announced an intention to take advantage of post-Brexit regulatory freedoms, and in their own words, to remove unnecessary bureaucracy. And what that seems to have entailed is a U-turn on the retained EU law Revocation and Reform Bill, the one with the snappy title. That's working its way through Parliament at the moment. And as originally drafted, the bill had a sunset clause in it, and that was set to revoke all EU-derived subordinate legislation, by which I mean UK regulations, not UK Act like the Equality Act, but all regulations derived from the EU on the 31st of December this year. That was the original intention. But there's been so much negative commentary around the upheaval that it was going to entail for the legal system that I think the government have been listening. And what they've done is remove the sunset clause from the draft legislation. And instead, the bill now has a schedule in it with approximately 600 regulations listed there that will be eventually revoked. And the good news from our point of view is none of them are significant in an employment law sense. And I think, so, you know, for UK employers moving forward, it's generally going to be business as usual. But at the same time, the government also proposed a package of reforms in a consultation paper titled Retained EU Employment Law Reforms. That's open for comment until 7th of July, if any of you have a free morning to put together some comments. And it requests views on proposed changes to both the working time regulations and TUPE 2006. New slide, please. So just thinking first off about what is proposed in respect of working time. The first one is to remove the requirement to record the daily working hours of workers. And some of you might well be thinking, justifiably, what requirement? I think it's one that's largely ignored in practice, but EU case law back in 2019 clarified that in order to comply with the provisions in the working time regs about the 48-hour working week and daily rest breaks, employers should have an organised system that records daily working hours. So this one, I think, is a bit of the government conducting a tidy-up exercise rather than making any significant changes. But the next proposal relates to holiday, and it's a proposal to amalgamate the current statutory holiday entitlement that UK workers have into one pot of 5.6 weeks. So at the moment, under the working time regs, workers have 4 weeks leave, which is based on EU law, and an extra 1.6 weeks leave, which is entirely UK specific. And I think having one pot of entitlement creates an opportunity to streamline the current rules that apply. Because based on previous EU case law, we have slightly different rules that apply to the different batches of holiday entitlement. So the government's proposing in relation to the calculation of holiday pay that they look at streamlining the calculation that employers apply so that it all applies to one 5.6 week pot. And you may recall from EU case law that there's some inconsistency about whether holiday pay should be calculated on the basis of normal remuneration, taking account of extras like overtime and commission, or whether it should be calculated on the basis of basic pay, as is currently the case in respect of the extra 1.6 weeks UK holiday. So broadly, the consultation seeks views on the best way to define holiday pay moving forward. It also looks at the potential for clarifying carryover of current statutory holiday. At the moment, it's not permitted in respect of the 4 weeks EU law holiday, unless it's for an exceptional reason, like an employee's not been able to take it based on long-term sickness or maternity leave. whereas in respect of the 1.6 week UK holiday, it is possible to carry it over. So some clarification there would obviously be helpful. And the final point on that is that new joiners the proposal is that new joiners would accrue their holiday entitlement at the end of each relevant pay period during their first year of employment. So again, another sort of tidy up exercise. And what that means in practice is if a new joiner receives a monthly salary, then that's the point at which they would accrue monthly holiday during their first year. An interesting potential development is the introduction of rolled up holiday pay. And the proposal is to allow employers to roll up holiday pay into an employee's normal remuneration so that they'll receive it in regular increments throughout the year rather than specifically when they take holiday. And this practice was generally banned as a result of EU case law back in 2006, but it is still used fairly regularly in some sectors. The idea is that employers would be allowed to use the calculation of 12.07% pay, and that's recognised as being the proportion of statutory holiday versus working weeks in any given holiday year. And this would be permitted provided workers knew that it was happening and that it was specified in pay slips. I think it's one that can be useful in the context of casual workers who perhaps have irregular hours or short-term contracts. But interestingly, the government proposal is that it potentially could be applied in relation to all workers and employees. Next slide, please. The consultation paper also proposes some changes in respect of the TUPE consultation regime. And the overriding sort of aim is to simplify the transfer process. So small businesses with fewer than 50 employees would be permitted to consult directly with their employees rather than with elected employee reps. And that's broadly an extension of the current micro-business exception which exists under TUPE, and that currently applies to employers with fewer than 10 employees. And then a further change would be to allow businesses of any size to consult directly with employees if there will be fewer than 10 employees who are affected by the transfer or who will be transferred under the regs. And I think this one appears to be pitched at service provision changes, so perhaps small outsourcing situations where only a few employees are affected, or where there's the sale of a small part of a larger business. And do remember, though, that if employee reps are already in place in either of those cases, then the employer would still be required to consult directly with the representatives, not directly with the employees. And then there's also been a general call for some views on how TUPE could be best reformed, and I'm sure probably we all have a view on that one. Next slide, please. And then the final sort of interesting point I want to raise is that the government has confirmed its plans to put a 3-month time limit on non-compete clauses in employment and worker contracts. And this follows a consultation that took place back in 2020. And the government's conclusion is that non-competes have become something of a default clause in many employment contracts, and therefore that reform is needed to boost competition in the UK job market and to remove barriers to recruitment. At the moment, all post-termination restrictive covenants are governed by the relevant case law in this area. And the underlying principle is that they should be no wider than reasonably necessary to protect the employer's legitimate business interests, such as client connections or confidential information. And in terms of duration, the courts generally consider 12 months to be at the outer limit of what's enforceable in an employment context. So we're looking at a 3-month limit for non-competes in the future, and that will be brought in when parliamentary time allows. It's kind of an often used phrase. I have no idea what it means. It doesn't help in terms of assessing timescale. But a key takeaway is that the limit is not going to apply to other restrictive covenants such as non-solicitation clauses. So they'll still be covered by the view of the courts as to what's reasonable in the relevant context. Practically, I think there's likely to be an increased reliance on garden leave and notice periods. And in one sense, I think because the employee remains employed while they're on garden leave or on notice, and therefore subject to their contractual obligations, and they're still being paid, it's easier to delay them joining competitors on that basis rather than to argue over the enforceability of a non-compete restriction. So it will probably be possible to achieve much of the same result, albeit by using a slightly different method or adjusting notice or garden leave periods. And it's one that's likely to cost employers more money in comparison to unpaid post-termination restrictions. And the consultation also states that the limit won't be applied to wider workplace contracts, and that would include shareholder agreements or LLP agreements. And this is on the basis that it's generally accepted that the balance of bargaining power is a bit more equal in those circumstances rather than the situation in an employment context. But I think we will need to look quite closely at the definition that comes out of the consultation so that we have clarity on that. And generally, as I've said, the timing is pretty vague here, but I think this is one we'll keep a close eye on and we'll update you. And my sort of parting comment would be to encourage anyone who hasn't already to sign up for our HRLaw bulletins, because these are the types of issues that we cover regularly in that. So that's pretty much everything for me. I think it's probably time for us to look at some questions.
Thank you, Kerry and Grace, for that, particularly to Kerry for stepping in at the last minute with that last section, which I hope you all found very useful. So we've got a question and a comment. The first one, how would you score those at risk of redundancy, 1 to 10 or what? Grace, are you able to answer that one?
Yeah, thanks, Jo. So I think it's an interesting question, but there aren't really any hard and fast rules as to how you have to score. I mean, you might choose 1 to 10, you might choose 1 to 5, you might choose 1 to 100. I think it's worth bearing in mind that the smaller the numbers you use, the smaller the range of scores you will ultimately get. So it largely depends on how many people you are scoring, and also whether you can kind of accurately assess people's performance in the difference between for example, the difference between a 4 and a 5 might be sort of 80 to 100% if you're only 1 to 5, or it might be 10%. So I think it's important to kind of look at who it is you're scoring. The other thing I would say is that you may wish to weight different criteria in different ways. So it might be that you're using figures 1 to 10 to score, but then giving different weightings to particular areas that are more important to you. For example, financial performance might be the most important thing, and that might be something you want to weight more heavily. Another approach is to have a look at how you currently score in appraisals and things like that. So it'll be a scoring methodology that your employees are familiar with. But as I said, there aren't any hard and fast rules. It's just about making sure that the criterion you select are fair, and then once you've got a fair criterion, you're then scoring that fairly and accurately given somebody's performance.
Great, thank you, Grace. So the comment we had is that from one of you that they have a 3-month non-compete. They're interested in the 3-month non-compete situation because they have 9 months for all staff. And I think it's not uncommon that many of you will have longer periods at the moment for your non-competes. I would say leave them as they are for the time being, unless of course you are wanting to review your contracts in any event, and you might want to have a think about whether in anticipation of that legislation, you might want to reflect some changes there. But obviously, if the legislation does change, you will just need to notify all of your staff of the change to their contracts where they do have longer non-competes, but you can do that when the time comes. We've just had another question in. Thank you. What's the best approach in dealing with an employee who goes off sick long-term prior to a selection interview, whilst all other candidates have been interviewed and are having to wait for the outcome? Kerry, Grace, I don't know which one of you wants to handle that one.
Will I start with that one?
Yeah.
Yeah, I think it brings into play all the factors that Grace spoke about in her section. I suppose in terms of going off sick long term, it would be relevant what the condition was and why they'd gone off sick, and whether it was treatment, whether it was instantly something that could be considered a disability under the Equality Act. in which case you've engaged the positive obligation to make reasonable adjustments, or whether it's something that at this stage wouldn't necessarily be classed as a long-term disability, might not be likely to last for longer than 12 months at that point. But I think you would need to do your best to still engage with that individual, to try and show some flexibility and engage in some form of consultation process, albeit you might have to make quite a few tweaks as to when and where and how, and even who is able to accompany the individual. For example, it might be more appropriate for a family member to attend with them, or to take part in the consultation with them. So I think there's lots of different things in the mix, but you don't have to long term entirely put the redundancy process on hold, because I think the courts and the tribunal do have some sympathy with the fact that it's very unfair on other staff to have to wait indefinitely for a decision as to the outcome for on their redundancy. And Grace's point that she made is obviously that someone who's on disability isn't automatically entitled to be given any suitable alternative vacancy that might exist in the same way that someone on maternity leave would be. That's just my sort of initial thoughts.
Brilliant. Thank you, Kerry. If there's any more questions, now is the time to pop them in there. But in the absence of that, thank you very much, everybody, for coming along to the session this morning. Again, apologies that we weren't able to bring you the immigration checklist, but we will be dealing with that at a future event. I just wanted to also mention, some of you may already be signed up, but if you're not, we have an HR law training on the 13th of June with Selwyn, who many of you will know through the HR law training programme. It's actually a free session, and it's going to be dealing with the difficult question of harassment. So if you haven't signed up, please do let your normal contact at Fox Williams or me know, and we will get you signed up for that event. So thank you very much. I can't see any more questions coming in, so we'll say goodbye for this morning. Look forward to the next HR Law webinar, which I think will be taking place in the autumn now. Thank you, everyone.